So today's topic is drafting of pleadings, and I'm going to speak to you about it in a little bit of a informal and detailed manner. The drafting of pleadings is an art which you get better at with practice over time. It's not something that will come magically. It's not something that will come instantly. But the more opportunities you get to draft and the more opportunities you take and practice the art of drafting, the better it is. Ultimately, since it is an art, there is no magic formula or cookie cutter method to draft pleadings. It comes with trial and error and a lot of help and editing by seniors, colleagues, etc. It'll take a while to get good at it. But then after a while, you get really good at it, you get the knack of it. So I'm here to give you some general tips and advice on drafting pleadings and how to go about it. But I must give you this caveat that there's no right or correct way to draft. Ultimately, drafting is subjective. Many people have different styles, different methods of going about it. As long as the basic requirements are met, any draft is okay. After all, the basic requirements are what is necessary to prove your case. But after the basic requirements are in place, it's a matter of style and convenience. I feel, having been trained by seniors on the original side of the Bombay High Court, that certainly there's a more effective and aesthetic way of drafting, and therefore, what I will speak to you about will make the difference between an okay draft and a really good draft. These are the conclusions that I have arrived at after several years at the bar, and therefore I will be giving you these tips. However, firstly, these rules are not exhaustive, and moreover, these rules can be broken on occasion if you must. But if you're just starting out in practice, then I would urge you not to break these rules. So let's get right into it. And let's start with really the basics. So, the first question that we have to answer is, what are pleadings? Now, pleadings are really formal statements of one's cause of action or of one's defense. Cause of action if you're the plaintiff, and defense if you're the defendant. These are filings which are given in court and form the basis of all your arguments. And therefore, really speaking, pleadings are the backbone of any court matter or of any litigation. For example, a suit, as is mentioned in the Civil Procedure Code, is instituted on the presentation of a plaint. Similarly, a written statement is the written case of the defendant in order to defend a suit. So these are really the pleadings which give rise to a suit and which by which one defends a suit. So these are vitally important and are, if you intend to enter into litigation, are essential skills to draft. Now, before we go a little further into pleadings, why pleadings are important, etc., let us just discuss what are not pleadings. And there are several things which you will draft as a lawyer which are not considered pleadings. For example, transactional documents such as contracts, conveyances, etc. They are obviously not pleadings because they are not filings which you submit to court. Also, they're different from pleadings in the sense that you can use a cookie cutter method, you can use a precedent for and modify it appropriately for your case. Ultimately, they are transactional documents involving conferring a right or obligation on one or more parties, and therefore they are not pleadings in any manner whatsoever. Many times, people are confused as to whether affidavits of evidence can be considered pleadings. And the answer to that is a resounding no. Affidavits of evidence are those affidavits which are filed under Order 18, Rule 4 of the Civil Procedure Code. And what essentially this code, this order, and this rule provide is that in lieu of examination in chief, affidavits are permitted to be presented at the time of trial. Now, these affidavits are those that contain evidence alone, which are to the personal knowledge of the deponent, and do not contain any assertions of law or any arguments, submissions, or amendments. That is how they are different from pleadings which we file in court. Affidavits of evidence are entirely different. And why are they known as affidavits in lieu of examination in chief? Because they substitute the need for taking examination in chief either before the court or before a commissioner. And if you want further information on this, you can look at the case of Dilip Nevatia, Harish Loyalka's case, passed by Justice Patel of the Bombay High Court. Now, we are not concerned with these kind of documents today. And the reason that I emphasize this is because drafting of evidence affidavits is very intensive and a totally different discipline from drafting of normal pleadings. Different rules entirely apply, and hence I will not be covering these today. Thirdly, another kind of drafting that you will do when you are an advocate or when you are a litigator is correspondence between the parties. This is also not considered a pleading, so we're not going to cover that. Now, having given you that background of what we are going to cover, let's discuss a little bit about why pleadings are important. Now, pleadings, as I told you, are the backbone or the foundation of your case. In your pleadings, you crystallize your case in black and white. Once the plaintiff has put something in writing, the defendant gets an opportunity to meet the case of the plaintiff. And vice versa. Once the defendant has put something in writing, sometimes the plaintiff is entitled to a rejoinder to meet the case of the defendant. So, therefore, the purpose of pleadings are really to give the other side an opportunity to meet your case. Otherwise, natural justice will not be met. And also to crystallize your stand on a particular issue. Now, another reason why pleadings are important and why pleadings are almost cast in stone. Of course, you're permitted to move applications to amend pleadings, but pleadings are something which a party cannot travel beyond. Parties are therefore bound by their pleadings. What they have said in their pleadings are binding on the parties, and if they do or say something contrary to their pleadings, then there will be an adverse inference drawn. Moreover, arguments outside pleadings cannot be considered at all in a court of law. There are several judgments on this. One of the leading judgments is a 2008 Supreme Court judgment in Bachaj Nahar versus Nilima Mandal. You can take the citation. It's 2008-17 SCC 491. And there, what this held was the fundamental rules of civil procedure. The absolutely fundamental rules of civil procedure include, firstly, that no amount of evidence can be looked into upon a plea which was never put forward in pleadings. Further, a question which did arise from the pleadings and which was not the subject matter of an issue cannot be decided by the court. Now, what does this mean? It means that a party cannot go beyond the pleadings, and a court itself cannot decide on a question which did arise from the pleadings and which was not the subject matter of an issue. Further, secondly, the Supreme Court held that a court cannot make out a case which is not pleaded. So a court itself cannot make out a case which does not form part of the pleadings, and the court must confine itself to a decision on the question raised in pleadings. A court cannot even grant a relief which is not claimed and which does not flow from the facts and the cause of action alleged in the plaint. So, therefore, you understand that the pleadings and what is stated in the pleadings becomes vitally important, and parties cannot travel beyond that. Moreover, in pleadings, one cannot approbate and reprobate. That is, one cannot have it both ways. What this essentially means is that a party cannot, on the one hand, say one thing and on the other hand, say the direct opposite. The principle is based on the maxim quod approbo non reprobo, which roughly translates to that which I approve, I cannot disapprove. And therefore, an individual has to either accept the entire fact or reject the whole thing. Therefore, essentially, a party is tied down to one stand. Now, what are the necessary averments that you need to make? For example, in a suit for specific performance of a contract, prior to the 2018 amendment of the Specific Relief Act, Section 16C said that one has to plead, that is, one has to aver and prove that they were at all times ready and willing to perform their part of the contract in order to obtain a decree for specific performance. Now, of course, that law has changed and one is only required to prove it during the trial stage. But this goes to show that certain pleadings and certain averments are absolutely vital to your case, and without them, your entire case can be demolished. For example, in a recent matter, or in a matter which was about 3 or 4 years ago, the trial court allowed the amendment of pleadings permitting the plaintiff to make necessary statutory averments which were missing in the plaint, similar to Section 16C. Now, I was appearing in that matter, and we had filed an appeal from the trial court to the High Court, and the High Court overturned the trial court's ruling, stating that the failure of a party to make a necessary averment without due diligence at the time of filing and the pleading amounts to negligence, and the party should not be awarded for negligence. So, therefore, what you state in your pleading has to be carefully worded and has to contain the necessary and statutory averments which are required. So that's also why pleadings are important. On the other hand, in a written statement, if a defendant does not file a written statement, it is the same as if a suit is going undefended. And therefore, only the plaintiff's case will be looked at, and the entire suit can be decided on that basis. Now, if we talk about speaking the truth in pleadings, if one does not speak the truth, if one says incorrect statements after verifying that those are to his knowledge and to what he believes to be true, then that person could be held guilty for the crime of perjury. And also, that person would be guilty of suppression. Now, the suppression would be, there are two kinds of suppression of the truth or suggesting false statements, which means that the person has not approached the court with clean hands. And if a person is guilty of suppression and does not approach the court with clean hands, then he may be disentitled to grant of discretionary reliefs. So all these are reasons why pleadings are important. It has to be in writing. Everything cannot be oral. The basis or the foundation of your case has to be in your pleadings. All right. So that is why we say that pleadings are vitally important. Now, the second thing that I want to talk to you about is general rules while drafting. So we spoke about why pleadings are important. We spoke about what are pleadings, but the general rules while drafting are the same everywhere. And the first thing that you do when you meet a client is you understand the facts and hear the client out. Then the second thing and the most important thing that you can do before drafting your pleading is preparing a chronology, what we call a list of dates and events. Now, why is this such an important document? A chronology is basically a document which provides the date and the corresponding events in chronological order. It is the most important document for preparing and drafting your pleadings. It crystallizes your case in your own mind and puts it into perspective, and you become organized in the same vein. So, when you do eventually argue the matter, the list of dates and events, along with cross references in the pleadings and in the exhibits, can be used for your arguments. What we call this is an arguing list of dates, and sometimes you present it to the judge and to the other side as you read it out. I won't go into detail about a list of dates, but trust me, it is going to be a boon to your drafting and to your arguing. And this is the first thing that you should do as soon as you are presented with documents for a new matter. Now, all this is to emphasize that the facts are the backbone of your pleadings. And therefore, the facts have to be, you have to know the facts inside out, and the facts have to be foolproof completely. After the list of dates, do you immediately start drafting? You don't immediately start your dictation. Classically trained litigators will first thoroughly research the law and then prepare internal notes on what the law is, including research on case law. So, first you get the facts in order, then you analyze the law from all angles. I personally like to use this method which I learned called IRAC. IRAC. It's a form of analysis. It stands for issue, rule, analysis, and conclusion. So first you analyze the issue. The issue is fact-based. So what is the issue or the dispute between the parties? Then secondly, you use the rule or the rule of law which applies to those facts. You write them down and analyze that. The third is the analysis. So you apply the law to the facts. And then the last is the conclusion, the final conclusion that you arrive at after analyzing the law and the facts. I prefer to use this method as it really organizes any matter for me. And this approach is often taught in law schools abroad, uh, for example, in the US and the UK, but rarely in our education system in law school. So, therefore, I find this really useful. You can use it as well. After you have done all this exercise, this is prior to drafting, then finally you begin drafting. Now, personally, I prefer dictation, and this is a method of drafting, and I'll tell you why, as opposed to drafting myself in a Word document. So, for the first several times, you may want to draft it yourself in your by typing it out in a Word document. But it's good practice to give dictation to stenographers or to use a dictation software. Why? Firstly, it's time saving and efficient. You can rarely type as fast as you can speak. It saves energy also because the dictation is actually taking down what you're saying and you're not wasting time typing. And so you can focus on reading the documents uh, and dictating what you want to write. Now, you can also continue dictating without pausing to type or without pausing to read documents, etc. And without having to bother whether you made spelling mistakes, typographical errors, all that can be checked later on. And lastly, why is dictation important? It's because you can practice clarity of thought and only say that which you truly want to be written down. You will naturally, while giving dictation, think twice and think what you want to write before speaking because you can't repeatedly dictate corrections. Especially if you're giving it to a stenographer, you wouldn't want to keep correcting what you have stated before. So, this will streamline your thoughts, organize yourself, and will eventually help you in becoming a better lawyer and better at arguing because it will mold you into more organized and clear thinking lawyer. Now, going into actual drafting. And finally, this is really what you're here for. This is usually the order in which I do things. If you are an applicant, a plaintiff, a claimant, a petitioner, I would generally start with drafting the prayers. The prayers are the reliefs that you eventually want. So, once this is the conclusion, this is really what order you want from the court. Although the prayers are put at the end of a plaint, at the end of a petition, generally speaking, once you know what the conclusion is and what you are leading to, then the rest falls into place. as I've learned over the years. So I generally start drafting the prayers and then I draft everything else. After the prayers, of course, you already have your list of dates and events, so you can put down the essential facts. And then lastly, I put in the legal submissions based on the facts. So that's again following the IRAC form of analysis: issue, rule, analysis, and conclusion. Now look at style. Let's look at a matter of what is good drafting. What does it look like? Many people think that using big language and using verbose language, repeating yourself is good drafting, especially writing pages and pages of the same drivel is good drafting, and that it will intimidate the other side. On the contrary, what I have learned is to keep your drafting concise and crisp, to keep it precisely to what you want to say. Avoid the legalese, avoid traps of using big words which serve no purpose. If you can say something simply and in a concise manner, then do that, because you have to get your point across to the judge as quickly as possible. Avoid repetition in pleadings. If you have said something once in one manner, you do not need to say the same thing again in another manner. It's very irritating to judges and it's also distracting. Of course, this is not set in stone. If you're deliberately trying to emphasize something, you can repeat it. But as far as possible, do not repeat the same point. It's just messy and it's unesthetic drafting. After that, don't write, don't think that if you write pages and pages of the same thing, it will help your case. As I mentioned before, the pleading must be precise and accurate. Sometimes it can be as short as a page and a half. I have personally been involved in a matter in which I was tasked with drafting a petition. What started off, what I thought started off as a relatively concise 10-page petition, as per my instructions, was eventually whittled down into 2 pages. That's it. And we filed that, and that was all that was required because it contained exactly the requirements that we needed. Another rule or another tip that I will give you is, if possible, use open language while giving the necessary particulars. What I mean is, don't be vague, don't be ambiguous, but keep some wiggle room for later, maybe at the stage of evidence or trial. Keep it slightly open so that you have that opportunity to advance your position in a more detailed manner at a later stage. For example, when drafting a plaint, the essential to drafting a plaint is that it must disclose a cause of action. And many times that cause of action may be beyond the limitation period. If that is so, as far as possible, try to not tie yourself down to a particular date saying this is the date when my cause of action arose. Because if you do that, then at a later stage, you cannot argue anything to the contrary, or you cannot argue anything which is even more beneficial to you. So, especially if there's a doubt that the suit is filed beyond limitation, try to just make a statement saying, of course, you need to disclose the relevant facts saying when you discovered, etc. But don't say the cause of action arose on this particular date. Say that the suit is filed within limitation, and then leave it to the defendant to raise the point that the suit is filed beyond limitation. If that is the case, then there will be an issue framed and you will get an opportunity to prove that the suit is filed within limitation. So therefore, the onus is on the defendant in this case. Now, one really interesting and important tip that I will give you in drafting pleadings, and it may sound a little informal or funny, but this has helped me to know, and it's known as murder your darlings or kill your darlings. Now, this is a popular piece of writing advice that can be traced back to an English writer and collector by the name of Arthur Quiller Couch. He was knighted. And of course, this expression is not meant to be taken literally, but rather it's a metaphor for how you should behave towards your writing when you are revising it. The idea is to proceed objectively and without sentiment, and to remove portions of your draft which are not taking it further. For example, you may think you have written a beautiful draft in the first draft, and but there is certain superfluous uh, jargon which you have added, or a passage or a paragraph which need not be there, which just goes one step too far. And the idea is to proceed just like you would do with killing your favorite uh, passage. You have to cut it down if it does not help your case, if it does not take your case further, and if it distracts from the main proposition in your case. So while this is usually applied to writing and writing literature, I found this really relevant even when writing or drafting pleadings. So this is something that you can keep in mind. Avoid jargon is another tip that I can give you. For example, many times when you're drafting a reply or a defense, then what lawyer says at the outset, I would like to say so and so, so and so. There is no reason to say at the outset. There's no such thing. Everything is at the outset. Keep away from such archaic legalese because it's not necessary. Another type of phrase that is used often is in an affidavit when people say, I say so and so. When you are filing an affidavit, it is always in the first person. You do not need to say something, you do not need to say that you are saying something. Just say it. So that I say that so and so, that I say that needs to be removed. It's a very bad habit that we have on this side of the on in pleadings, that we keep repeating that phrase, and it's completely superfluous in my opinion. Now, another phrase which is very overused is and slash or. Lawyers love this phrase, both transactional attorneys as well as litigators. And on most occasions, if you look at it, and slash means either it means or it means and. So think about what you're using it for. And most of the time, you really don't need to use and slash or. It's completely meaningless and overused. So these are a few of the, keep an eye out for these kind of phrases, legalese, which you keep repeating, but which really don't help your case. If you look at pleadings in other countries, especially in the US and in Canada, and to some extent in the UK, although they still use some sort of legalese. But if you look at these kind of pleadings, it's matter of fact. It's completely informal, though I'm not saying that you should be informal, especially in India. One must be, somewhat formal in your pleadings. But at the same time, we must, as a conscious effort, step away from using legalese, repeating ourselves, etc., etc. So these are some suggestions that I can give you, and then you can come up with these yourself once you read a number of pleadings and start drafting yourself. Now, one thing that I learned very early on by my learned seniors in the profession is that at least when you're drafting a plaint or a petition or a memorandum of appeal, you should include, before you get into the entire facts, a short summary of the entire cause of action in one or two paragraphs right at the beginning of the pleading. Now, how does this help? Look, let's be frank. Judges are overburdened. They are dealing with 40, 50, 100 cases a day. They don't have time to read the entire pleading cover to cover. So, therefore, if there's a short clause or a short summary right at the top, right at the beginning, then it can only help your case, because then the judge is more inclined to read it and get a gist or a summary of what your entire pleading is about. So, and that was colloquially named after one of the judges of the Bombay High Court. It's known as a short summary of an entire cause of action. Another tip, another rule that I would suggest is to temper your language when you're drafting. One does not need to vehemently deny. One can simply deny a fact. Suppose there's some allegation which has been made against your client. In reply, you don't need to use such words as vehemently deny. Doesn't take your case any further. Reduce the use of adjectives. If you have to state the same thing, say it once. If you have to state some sort of a adjective, say it once. As in, don't keep repeating about how the other side is a liar and this and that. Be assertive, but don't be aggressive in your pleadings, because that just does not sit well and sometimes can uh, not be taken well by the judge as well. Another tip, which usually we don't do, is that we don't put headings. If you are really organized in your thought and you're giving a draft which is thoroughly organized and which is uh, good, then you must put headings on top of each point that you're trying to make. For example, if your case is that say, for example, an application is made, and if you're filing a reply, you can say that the application suffers from gross suppression as a heading and then give the reasons why. Or you can say that the application is replete with false statements and half truths, or whatever you want to say, but put a heading so that the person reading the pleading knows what the topic of that entire passage is and gets a gist of it immediately. Another tip that I will give you, especially when you're just starting off, but it applies to anyone who's really making a draft, is when you draft, after that, look at it again and redraft the same thing, because your first draft is never going to be your best draft. After you redraft it and edit it, keep it aside and then look at it again after some time. Make it easy so you need to constantly edit your draft, constantly update it at least a few times. If you cannot do it yourself, and if you have uh, if it's a time consuming process, no doubt, but it is extremely rewarding. You get better and quicker at editing your draft, and if you're tired of rereading your own draft again and again, ask someone else with fresh eyes to look at it. Make it extremely easy for the judge to comprehend and understand your pleading. If you cannot explain it in simple words to the judge in a pleading, the judge, who himself is hard pressed for time, may not have the same patience and time to read and analyze everything, and certainly will be a little lost. So keep it simple, keep it precise, keep it concise. Don't jumble up your thoughts. Three tips that I will give you is two tips rather, which are really very essential. One is typographical errors matter and reflect poorly on you, on your client. So do not make errors in spelling, cross referencing, or dates. Especially dates and cross referencing are very important. So therefore, proofread your document when you are done drafting it. Similarly, formatting also matters. Make the draft look good, make it look professional, and it goes a long way subconsciously in the mind of the person who is reading it, whether it's a counterparty or a judge. Now, all of this style based thing, that is not to say that the content or the substance should not be good. No matter how your formatting is, no matter whether you made typos, the content is obviously king. It should be substantive, there should be law, there should be submissions, there should be facts. But eventually, formatting, definitions, eliminating typographical errors, all really goes a long way in making a draft really good. So keep that in mind, and it reflects well on you if there are none of these errors. Another tip is that always look at the documents before drafting. Even if your client is saying a particular fact, first satisfy yourself that what your client is saying is accurate and tenable Do not blindly put something in that uh, your client tells you to do. Use your independent thought. Ultimately, you will be arguing your case and will be standing in court. And if you're arguing something which is palpably false, incorrect, untenable, it will be your reputation which will be at stake in the eyes of the court. So be very sure and always look at the documents on the basis of which your client is saying something. Now, at the end of your drafting procedure, get the draft confirmed by your client. There is something known as a verification clause in any pleading. This is important and it's vitally necessary that it is accurate. What the verification clause says is that the person, the deponent, identifies paragraphs which he is saying on oath are either what he believes to be true or which he actually knows to be true and correct. So if one makes mistakes in the verification clause, it can lead to severe consequences at any stage of the trial or any stage of the suit for that matter. So these are a few tips that I wanted to give you. Now I'm going to also give you specific tips on different kinds of pleadings, um, such as drafting of a plaint, drafting of a written statement, counter affidavits, rejoinders, etc. Now, what are the different types of pleadings? Uh, the first and most common pleading which we practice on the original side of the Bombay High Court and in any trial court really is a plaint. That is the document by which one institutes a suit. So a suit is instituted by presentation of the plaint in court. Now, what are the necessary ingredients or what are the necessary things that you must mention in the plaint? Of course, there's the cause title. Then you must first, or what I usually do is to keep it concise, to keep it clear, is I give a brief background about the parties. And this is normally what we do in plaints. After that, as I mentioned, you must put the summary paragraph. And the summary paragraph really gives the entire cause of action, a summary of the entire cause of action, so that the judge need not read the entire pleading and can go straight to the prayers. Then the facts which disclose the cause of action. The facts must be detailed and must contain all the relevant facts without suppression, even if the fact is inconvenient to you. I have noticed that even if I give a fact which is bad for my client, but if I have disclosed it upfront, I can spin it in a way that it is for the benefit of my client. So must disclose all facts and not suppress anything. Then after that, there are the legal submissions, which come after the facts. Of course, the facts must be in a chronological manner and in the manner in which they were discovered. After that, the submissions. Then the necessary and statutory averments, for example, jurisdiction, cause of action, limitation, no other suit or proceeding that has been filed on the same facts or cause of action, uh, court fees, etc., etc. And then last is the prayers. But of course, the order in which you must do it is draft the prayers first, and then the facts and the legal submissions. The most important are your prayers. I have seen time and again where the judge is convinced of your case, but the prayers are worded such that they are not effective, or they leave loopholes uh, for the other party to do something which you don't want them to do. So the prayers have to be very, very tightly worded without leaving any openings. And consciously, one must do that. In one case, in fact, that I worked on, the whole matter was argued on the opposite side by a senior counsel. I was on the side of the respondent. And ultimately, it turned out that although the appeal was admitted, there were no prayers for interim relief at all. So On that basis, the appeal was admitted, but they had to file another application for interim relief, and it took another 6 months, and then eventually the matter got settled. So you must figure out what reliefs you want and then mold your pleadings accordingly. One thing that you must keep in mind while drafting a plaint is that you must have documentary evidence. At the time of drafting the plaint, you must look at the documents to make sure that you can prove what you are saying in the plaint. Because it's all well and good to say something in the plaint, but ultimately what is stated in your pleadings will go to trial, and therefore you will have to prove that at the stage of trial. So keep in mind what the documents are, what the evidence you have is, and accordingly draft the plaint. Now, similarly, a written statement. What is a written statement? It is a defense of the defendant, and it can include a counterclaim or a cross suit as well. And the same rules really that apply for drafting a plaint apply for drafting a statement of defense or a written statement. So I won't go into that in detail. But one thing I will say is that when dealing with uh, what is stated in the plaint, since you have the benefit of the plaint, you know what the plaintiff's case is. You must give a detailed paragraph wise reply and don't skimp or don't give a blanket denial. Give one when you're giving a reply, you may deny a fact, but then also give your positive case. Otherwise, it takes uh, your case no further. And why will a judge just simply believe a denial? You also need to give your positive case on the same thing for a judge to believe you. So that is a written statement. Then we have something known as applications and reply affidavits in applications that are filed. I won't go into applications much. They are much the same way as uh, a plaint. But some things in reply affidavits or affidavits in reply, I would like to point out. Now, these are affidavits which are not the same as evidence affidavits and therefore can contain arguments, averments, suggestions, etc. I would say when drafting an affidavit in reply, always give your positive case first under using headings, saying that this each point must have a separate heading, and then deal with the other side's arguments. I would encourage you to file to give a paragraph-wise reply. Not everyone does after giving your positive case. And when you do give your paragraph-wise reply, be thorough in your denials. Many people think that a paragraph-wise reply is not important and that judges don't read it or they themselves don't read it. But I have personally seen matters being decided on a lack of denial with respect to a single fact. In fact, in one such case, in a writ petition which I was appearing before the Bombay High Court, it was a division bench. We were for the petitioners, and the respondent had forgotten or had missed denying a vital fact in the affidavit in reply. The entire matter or the entire order was passed in favor of the petitioners on the basis that there was no denial of this vital fact. So always draft your replies with detailed denials and positive case in lieu of that. Um, so that is on reply affidavits. Sometimes courts also permit us to make rejoinders. One of the leading counsel in the Bombay High Court once told me, and we were discussing what to argue in a rejoinder. The arguments start with the plaintiff, then they go to the defendant, and then the plaintiff sometimes has a opportunity to rejoin. So he said, don't fall into the trap of answering the defendant's case point by point in the reply, in your rejoinder rather. So a rejoinder is meant for bolstering your own case while at the same time demolishing the case of the defendant or the respondent. So no need to go into bogeys which are raised by the defendants in detail. Stick to your game plan. Do make the necessary denials in your rejoinder, but don't be embroiled or don't get confused or into the red herrings and get led down the stray path. You stick to your game plan. That's it. So this applies not only to arguing a rejoinder, but also to what you state in your draft, in your affidavit of rejoinder. That's on affidavits of rejoinders. And now I'll just deal with writ petitions and memorandums of appeal. So writ petitions are much in the same way of plaints when it comes to drafting. The same sequence should be followed. But one thing which is a benefit in a writ petition, and even more so in a PIL, is that a writ petition need not be in a strict format, and you don't have to worry about going to trial because there's usually no evidence that is led in writ petitions. In a PIL, of course, a public interest litigation can be instituted even by sending a letter to the Chief Justice. So it need not be in any strict format. But adhering to these rules of general etiquette and general neatness and cleanness can really go a long way when you're drafting writ petitions or PILs. But in writ petitions, as I mentioned, there is no question of disputed facts, because if there is a question of disputed facts, then it will be relegated to a suit. So therefore, you are on a better footing in a writ petition. But that is not to say that you need not be as careful. Lastly, I'll just deal with memorandums of appeal. Memorandums of appeal, what are they? They are pleadings which you file in a higher court or a division bench of the same court, uh, appealing an order passed by a single judge or a lower court, etc. Now, in memorandums of appeal, you need not state the facts at all. You can if you want to, but it will just extend uh, the length of your document, which generally is frowned upon. As concise as possible is really the best way to go. So, in a memorandum of appeal, you just need to put in that summary clause. As I mentioned, a judge of the Bombay High Court used to really encourage people to do that because he had 100 cases a day on his board. So you would only read that one paragraph and then take it forward in the matter. So unless he was pointed out certain things. So, so therefore, in a memorandum of appeal, try not to put in the facts. Do put in a summary of how the order came to be passed, and then you have to just put your grounds of appeal. And similarly, even in a writ petition, you have to put the grounds on which you're filing your writ petition. So the grounds of appeal will be A, B, C, D, E, F. Many times, what people do is they keep repeating the same grounds in different words, which really doesn't take your case further. If you mentioned it once, that's good enough, and then go on to the next ground. So therefore, these are writ petitions and memorandums of appeal. Memorandums of appeal need not be so detailed and can be shorter as long as you've put in all the grounds of appeal. And typically, these are required to be filed within 30 or 60 days from the passing of the order. The limitation period requires that. So, therefore, there are these relaxations so far as memorandums of appeal are concerned. Now, these were the general types of pleadings that we usually draft. Um, the above is just my experience and my two bits. Feel free to improvise as you go along and carry these tips forward to juniors and other future generations. And of course, include your own tips. If you're just starting out, I would say don't be disheartened if your initial drafts seem very tedious and take very long time, and then they are filled with red markings and corrections from seniors if you are submitting them to seniors. That is a normal growing process that happens to everyone. Even the senior most of senior counsel at one point was a junior, and he was getting his draft settled by another senior. So you're bound to make mistakes, you're bound to learn from them. As I said in the beginning, drafting can be quite daunting and tedious, but once you master the art, it does become pretty enjoyable. and and you can really become an expert in drafting. So with that, I'll conclude the talk. So someone has asked, in case we keep the pleadings as short as possible, does that expose us to the risk as being perceived as not being in line with the normally acceptable length of pleadings? There is, firstly, let me dispel that notion that there is lengthy pleadings are good. In fact, the more concise and the more precise your pleading is, the better it is. If you have to put in some facts, do not skimp on that. I'm not for one moment suggesting you keep out, suppress, remove facts, but typically it is seen as good drafting, a sign of good drafting, if you can restrict the number of pages and the number of words that you use. So there's no such thing as the normally accepted length of pleadings. The length of pleading is as much as the facts of the case determine and require. The second question is, each judge's style of writing a judgment is different. Does styling your pleadings as per the judge have any incremental value? So now what I'm trying to explain in this session is that while the judge may write, he may have his own style of writing a judgment. Uh, Particularly when you're drafting something, it is to communicate your case as simply and as concisely as possible. So therefore, it's not a matter of style, it's a matter of putting it forth in the most simple manner so that you get the judge to understand what you have said. It's not really a stylistic thing. I'm not asking you to, or I'm not even suggesting that you put in certain kinds of uh, flourishes or anything like that. I'm saying make it as simple as possible, and that's the kind of style that I have realized is effective, especially in the original side of the Bombay High Court. Can we give case law reference in pleadings? While you can give case law reference in pleadings, and it's common, especially in writ petitions and affidavits in reply, I would not encourage you to put it in a plaint. Um, and what we typically do is we use wording from the judgment that we are going to rely on. Just copy that wording and use it as a part of your plaint as well, so that when you argue your case, you can say, look, I've said exactly this, and this is exactly what the judgment says. And then you have taken uh, the other side in some manner by surprise, although they are expected to know what the law is and expected to have researched the topic as well. But you need not serve it on a platter to the other side unless really necessary. Having said that, there's no restriction in putting case law in pleadings. Another question I've got is, what is the procedure for amendment of pleadings? So the procedure is typically you have to file an application for amendment of proceedings of pleadings, and depending on the stage of the suit, especially if the trial has not commenced, then the judge will usually allow you to amend your pleadings unless it's contrary or militates from the case that you have stated earlier. And if the trial has commenced and is completed, then there are several tests that the judge will apply, including whether the amendment is necessary to get to the real questions in dispute, etc., etc. There are all kinds of judgments on this by the Supreme Court, so you can look that up. Another question I've got is, how crucial is adding relevant section within legal submission paragraph? So I would say you do not need to add your sections at all. In fact, most of the time we do not add section numbers, and we just state that as per the law and whatever the law is. Then the other side is expected to know what the law is and expected to know which section we are referring to, or they'll research it. And in any case, the pleading is submitted to a court, and really the court would know the law, so you need not put in section numbers. And it's typically considered amateur drafting if you do include section numbers, etc. I mean, it's not really necessary. And someone has asked, what is a good books for drafting pleadings and conveyances? Well, the typical book that at least I studied when I was doing my solicitors was the Tijori Wala on drafting, pleading, and conveyance. But I'm sure there are other books that are out there and they are available. So, but of course, that book again gives you the basics of what are the basic requirements, but doesn't really tell you about style and conciseness and efficacy. So, that is something that you develop by speaking to others, by attending talks like these, by practicing. And I don't think that book would also tell you about style, efficacy, etc. Thanks a lot for having me.